I could candidly address the court with a recommendation on how to handle this case and explain why, I'd like to start that way.
I read it.
Your Honor, in this case, my client had been given a judicial diversion and then allegedly skipped out on it. And I had filed a motion which I had whipped up in a hurry when I was appointed to this case. And it doesn't explain well what my objections were, which is basically that it looked like we filed the wrong paperwork. Instead of doing the paperwork through judicial diversion, we've done the paperwork as if it had put on regular probation. And there appears to be an open question that I was ruled against on, in the sense of I thought it was so obvious that the judge should just throw the whole thing out last time. It's not quite so obvious as it's now pointed out to me. And I want to make sure my client is treated fairly and that everybody understands the nature of the objection I'm making and why. With all that said, I'm not just trying to win cases on technicalities either, and my client didn't come up with this objection. If Your Honor if everybody were agreeable to release her, put her on probation and set this whenever Your Honor wanted to, we would be happy to do that. And I would be happy to explain further, both to the state and to Your Honor.
Well, was she on unsupervised probation originally?
I think
she was on probation.
She was on probation for a regular judicial approach.
Right. Which is that we put them on probation. When it's a judicial diversion, we defer the prosecution and place them on probation.
Exactly.
So by deferring the prosecution, she doesn't have a conviction. And as a result of that, now the case becomes active again. And therefore, she's now facing the original charge. I'm trying to see if I can find out what it was.
I believe it's specific to the possession of cocaine, Your Honor, is my recollection.
So simple possession of cocaine. So General, what his argument is that because it's judicial diversion, she's never been actually found guilty of this crime to be able to revoke her and send her to jail. And I think he's correct. So, but what it does is it revokes her probation, revokes the judicial diversion provision, and puts it back on the active docket to prosecute from the beginning of the original charge. So I will order that the judicial diversion be revoked, and will order that the matter be returned to the active docket of this court, and we will set it for status on the January 12th date.
We'll have to work something out.
Okay. That's the judgment of the court.
Your Honor, she's been held without bond for 60 days now. I don't know if Your Honor is ruling affect all, whether she is released, reinstated to probation, being held without bond, or reinstated through the original bond case. I would, of course, ask that she be released and placed on probation.
She's not on probation unless she's being convicted.
Or
if she wants to plead guilty today to the charge, then she can be placed on probation. But beyond that, she's awaiting trial like any other defendant whose case has been reinstated.
Yes, Your Honor. Does that return her to the original bond then, or do we need to?
No, we're not, because she's violated the terms of that original. So the original bond doesn't necessarily mean that she would be entitled to a bond at all, or that it would be the same bond, because the allegations are that she has violated the terms of the probation that she was on for the judicial diversion. For that reason, it would not be, she will not be reinstated to the original bond. We can have a bond hearing, and I'll determine what, if any, bond is appropriate. So,
yes, Your Honor.
So you want to have that bond hearing today, or do you want to try to dispose of this case?
Oh, If Your Honor wanted to give us an opportunity to speak to the state about this, I would be happy to take that opportunity.
Might be worthwhile for your client to do that since she's already in jail, so. All right, we'll give you a few minutes to do that after we've concluded this docket.
Yes, Your Honor.
Here we have Cindy Compton. Ms. Compton's represented by Crystal Wilkerson. This is here for status. Have you heard or been in touch with your lawyer?
I've called her before, yes, secretary a couple times, but she's never returned my call. And I told her I wanted to take it to trial.
You want to take it to trial? All right, we'll give you a trial date. Is this a case I need to hear?
Doesn't have to be.
I don't care. I'm just don't know when your first trial dates would be other than April.
April will be my next, well, I already have a handful set in front of Judge Lockhart Mash for February. So April probably would be best. It'll be a one-day trial. I've made an offer in the case, but I haven't heard back from this.
Well, we have the state versus Paul Davidson set for the 14th and 15th, and we have Robert Kaiser on the 16th. Did we set something on the 15th as well?
We just let Paul Davidson roll over to.
Do you want to set this on the 15th?
I think that's fine.
Oh. Your case is set for April 15th for trial. Your lawyer will be notified and she'll need to get in touch with you, make sure everything's ready.
Thank you, sir. I'll make a note to email this first.
Yeah.
So the state would ask that she be back in custody, but I understand.
Call that a trifecta, is that what that's called?
She did admit to the cocaine and the alcohol use. She has not admitted to the methamphetamine.
Mr. Finley, you may head back to Clarksville.
Thank you, Your Honor. Good to see you, Judge.
Good to see you. Right, I've signed this Barnard furlough order and we are, whatever, is she out smoking or is she take off?
She is allegedly out smoking.
I find that there is a basis for the revocation of Ms. Hayes's bond. And as a result of that, she will be held pending the next hearing, which is January the 12th.
She's actually out on a medical furlough, which that would need to be revoked.
That's revoked as well.
That issue has passed.
If she's on a medical furlough and she is, has a positive for alcohol, methamphetamine, and cocaine, and she doesn't need medical treatment, she needs rehabilitation or jail, one or two, but she'll be in jail pending that January 12th hearing.
Yes, sir. Thanks.
All right. So are we waiting on the remaining inmates? Is that all we have left?
Yes, sir.
They, the females that were,
Might have a question. Cindy Compton, are we doing anything on her today?
or the what?
Cindy Compton? I have her down as, where's the Wilkerson is.
I have her as, she's an inmate,
Oh, sure.
Ms.
I wasn't
Wilkerson.
even thinking about that. She's coming up. Sorry, Judge, I didn't see that in there.
Have we heard from Crystal Wilkerson?
Step out and holler if you'd like.
Well, let's take up, Cynthia Burchett. No. Woman, this is your case.
Your Honor, Mr. Dodson has been approved for rehab at the Hope Center. I have been in communication with Ms. Utley at the Hope Center. They would not be able to get him out till Wednesday if Your Honor were to approve a settlement which would allow such a thing.
Yes, Your Honor, I've talked to Officer Potter. He's been wanting to go to treatment for quite some time, so reports an improvement. I mean,
I'll approve him to go into treatment as, if he's going to do so as a basis for it. Do you want to do it before he pleads on the violation of probation, or you want to?
Revoke.
That was our intention, is to plead to the violation of probation, reinstate the probation with this as a condition. And I just wanted to tell everybody, I just found out I can't go for this.
Well, why don't we do this? Are you saying plead to the probation violation and be reinstated with a condition of going to the Hope Center? Is that it?
Yes, sir.
All right. And Mr. Potter's in agreement with that? All right. Probation department.
Thank you, Judge.
Raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm by the testimony you give in this case to be the truth, the whole truth, and nothing but the true self you God?
State your full name for the record.
Gerald Eston Dobson.
Mr. Dawson, you're here today on a violation of probation. You've heard what the agreement is that the state and your lawyer have reached. But do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes, sir.
Do you understand that if you would have the right to have a lawyer and have one appointed if you could not afford your own, which I've done with a public defender?
Yes, sir.
Do you understand that if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a hearing into that appeal. All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
And that's going to reinstate you to probation on time served, but add an additional condition of your probation that you must enroll in and complete the Hope Center, and you will not be released from jail. You'll stay in jail until they pick you up or someone transport you on Wednesday of this week.
Yes,
You
sir.
understand all of these rights? You wish to waive your right to a hearing and plead guilty to this charge.
Yes, sir.
And then upon your plea of guilty, I find you guilty in order that you be revoked to serve your sentence, but by agreement with the state and on time served, I will reinstate you to probation in order that you be, have an additional condition of your probation that you enroll in and complete the Hope Center program. And good luck to you. I hope that it all goes well. Thank you.
She's gonna plead as charged to the simple possession of cocaine. We're gonna put her back on supervised probation with a zero tolerance when it comes to drug screens, Your Honor. She's been locked up 60 days. She should be clean, Your Honor. And we are also asking that she get a drug and alcohol assessment and follow the recommendation.
All right. Ms. Burchett, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm by the testimony you give in this case to be the truth, the whole truth, and nothing but the true self you God?
Thank you. State your full name for the record.
Cynthia Jane Burchett.
Ms. Burchett, you're here today charged with simple possession or misdemeanor possession of cocaine. Do you understand what you're charged with, and have you and Mr. Clemens had an opportunity to discuss this matter fully, and do you feel like you understand the charges, the sentence you're facing, as well as any possible defenses you might have? Well, it's indicated that you want to enter a plea of guilty to the charge of possession of cocaine. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, sir.
You understand that at trial, you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
But that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you ever get convicted of a crime.
Yes, sir.
You won't be able to necessarily come back in at the end of your probation and expunge your record as you were under judicial diversion. You understand that?
I understand.
You understand everything I've explained to you.
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? You understand I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty. You understand the court of the state could ask you questions about this offense, and if you answer the questions under oath, on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you're lying under oath.
Yes, Your Honor.
All right, then I will ask you the simple question: are you guilty of possession of cocaine?
Yes, Your Honor.
And how old are you?
I'm 24.
24. All right. I am looking at having to sentence someone who is about 24, 25 later this week, and the minimum sentence she's facing is 15 years to serve at 100%. Now, you're 24 years of age. If you have a decision to make, you can choose to pursue a life filled with drugs, and we'll see you in here periodically, and we'll send you up to prison for a while, then you'll come back out, and then we'll send you back again or we'll find you dead somewhere because cocaine is now being laced with fentanyl, and that happens. And I'll tell you a story. Had a case over in Cheatham County where husband and wife were going to celebrate they were a young couple like you, and they were going to celebrate their anniversary. Great time to be in love and to celebrate their anniversary. So the wife communicates with the husband and says, I've got a bottle of wine. Why don't you see if you can get us some Coke? So he goes out and he buys some cocaine, brings it back. Unbeknownst to him, that cocaine is laced with fentanyl. They found her dead inside the house, and they found him dead out in the driveway. They celebrated their anniversary by using drugs that killed them both. Because when you put that substance into your body at 24 years of age, you don't know where that came from or what's in it, and it could be rat poison for all you know. So you choose from here on out whether or not you're going to live and try to be a productive citizen, or you're just going to live your life teetering on the edge of prison or death. You understand that?
And my daughter very much like me alive, so thankfully I'm almost 3 years sober off that.
Oh.
So.
If you have a child, then you have a real reason to avoid that, because the other thing that I'll tell you about is that people who have drug problems oftentimes don't take care of their drugs, and they get their children exposed to drugs. Then their child, if the child lives, is going to have problems, and likely you're losing custody of your child and so forth. So it all boils down to you making good decisions from here on out at 24 years of age. I vaguely remember what it was like to be 24, and I'm not saying I made the best decisions, but I can tell you I didn't use cocaine. So I will tell you that you need to go through this case and make sure you follow all of the recommendations, because this is your one chance to get probation. If you violate this, you know what's going to happen. You're going to go to jail. You're not going to get any other consideration. I find you guilty of possession of cocaine in a misdemeanor amount. Sentence you to 11 months and 29 days in county jail. That will be suspended to probation. You are, as a condition of your probation, ordered to undergo an alcohol and drug assessment and follow the treatment recommendations that they give you. Good luck to you. I hope you've learned your lesson.
Your Honor, I noticed that as part of the agreement, Your Honor had advised her she had the right to a trial, proof beyond a reasonable doubt. I'd advised her, because this was a revocation of judicial diversion, that you had already convicted her and that this was an agreement as to sentence. That's not the.
Well, I've revoked your judicial diversion, which is different than you necessarily being found guilty of something. So while it may sound as though I found you guilty already, that's not necessarily the truth. But the evidence is there to find you guilty of this offense. So, all right, and that's the judgment of the court. Thank you. All right, then that concludes our business for today, and I think it is basically going to be